The session moderator is Professor Dr. Edgar Philippin, partner at Kellerhals, Carrard, Switzerland. His expertise extends to domestic and international arbitration and connections with commercial and industrial companies as well as with sports institutions. The other panelists are Axel Heck, attorney at law and INBA International Secretary Chair of Germany. Axel sir specializes in complex transnational transactions, international private dispute resolution, and strategic legal counseling with a strong focus on the Indian market. Then we have Leidylin Contreras, the Deputy Director, Directorate of Foreign Trade, Ministry of Industry and Commerce, Dominican Republic. Before joining the Directorate of Foreign Trade, ma'am was the Secretary General of the Dispute Resolution Center of the Chamber of Commerce of Santo Domingo. Then we have Elsa Sardinha, Independent Arbitrator, Research and Practice Fellow, Center for the International Law, National University of Singapore. Ma'am is a research associate in the investment law and policy and international dispute resolution research streams. Since joining the center in 2015, she has presented her sole authored policy and legal analysis papers for over 15 arbitration conferences. I invite Roopamdeep Sahni, advocate, Bar Council of India, Germany and India. Roopam ma'am has worked as an attorney and has worked with a sports arbitration law firm based in Munich. She is a member of the Basketball Arbitration Tribunal BAT and Munich and Court of Innovative Arbitration, Switzerland. Then I invite Miroslav Kabát, Ministry of Finance, Slovak Republic. Sir is a representative of the Ministry of Finance of the Slovak Republic. He is a member of the arbitration team based at the ministry, which is responsible for managing international investment treaty arbitrations. I request the moderator to kindly take over the dais.
Sort of in a parallel life, a lawyer, partner in one of the larger law firms in Switzerland. Edgar.
Thank you very much, Axel, for the kind words. Many thanks again to the Indian National Bar Association for inviting me. Last time I was here was 3 years ago, I think, but it's always a pleasure to find myself here in Delhi. The subject of our panel discussion is conduct of arbitration, a journey around the world, and we will try and show how and why it is important to organize arbitral proceedings in different contexts. Why? Because very often arbitral tribunals may be tempted to operate on autopilot, so to speak, just because they use boilerplate procedural rules that they do not really think about at the outset of the arbitration. But there are techniques for controlling time and costs of the arbitration, and that provide for an efficient case management. And I think it is extremely important in a country that promotes arbitration, such as India is doing now, that an increased effort be made to make sure that the proceedings are tailor-made for the needs of a particular case. And I think the chance in India is that insofar as there is really a will to improve and to promote arbitration, you have a chance to avoid mistakes that may be made around the world. And we are going to try and see how best practices have been set in place. In order to start the discussion, I would like perhaps to ask, at the outset of the proceeding, it's very important to shape the proceedings, and in that respect, procedural documents, procedural timetable is essential, and perhaps, Elsa, you would like to tell us a few words about that.
Procedural timetable number one, deciding on your procedural rules is an essential first step. It should happen as soon as possible after your tribunal is constituted, and that's something that applies to both commercial and investment treaty arbitration. Normally you'll have a panel of 3 arbitrators or a sole arbitrator. And for prospective arbitrators, a good practice point is to send the parties as soon as possible a skeleton or template procedural order to help guide them. And for counsel, if your arbitrator hasn't done this, isn't experienced, or isn't competent, this is something that you should also have in your sort of armory, is what sort of procedural rules do you want? If your arbitration clause doesn't specify specific procedural rules, then you need to decide that or agree on it with the other side. So decide whether, if it's an investor state arbitration, whether you want the ICC rules or the PCA or ICSID, and spell that out. Also decide whether or not the case warrants bifurcation, either between the sort of preliminary jurisdictional phase and the merits, or perhaps between the merits and damages, because that will really affect the timetable. And already start to think about an estimate of how many hearing days you might need your tribunal to reserve in advance, because that's also something that needs to happen immediately. Again, back to prospective arbitrators, you want to send this template out to the parties and ask them to confer amongst themselves, and then hold a teleconference, or if there's substantial disagreement between the parties, once you get their comments back, have an in-person hearing, hammer out those details, and then send it back to them and have them sort of agree on it. I think that's a good practice point for sort of both kinds of arbitration.
Thank you very much, Elsa. We may be coming back with questions for you later. But one point that I was wondering about, when at the outset of the arbitration you start thinking what the role of the arbitral tribunal is going to be, of course the arbitral tribunal is going to apply the rules of the law. But also, very often in international contexts, where parties are from different backgrounds, or where the applicable law is uncertain because the contractual documentation was improperly drafted, it might be for the arbitral tribunal to suggest to the parties that the arbitrators may decide the cause ex aequo and bono as amiable compositeur. And perhaps, Axel, you would like to tell us a little bit of the cases where it is appropriate for a tribunal to propose to resolve the dispute on the basis of equity rather than perhaps on strict law.
Yes, thank you. Well, the general rule in arbitration is that the arbitration is controlled by the parties. That's a big difference to court cases. But ex aequo bono, perhaps I should explain a little bit what it means. It is a Latin term which means what is just and fair, or according to equity and good conscience. Something to be decided ex aequo bono is something that is to be decided by principle of what is fair and just. A decision maker who is authorized to decide ex aequo bono is not bound by legal rules, but may take account of what is just and fair. And you find that enshrined, this principle or this authority, in many rules in the world that deal with arbitration and related cases. Now, what it means in practice, I can give you an example that I had myself as an arbitrator, where after the arbitration had started, and we had an arbitration agreement that had in the contract that provided for one specific law to be applied. I nevertheless, as the arbitrator, asked, there was an ICC arbitration, and that's possible under the ICC rules, whether they nevertheless authorized me to decide the matter ex aequo bono. So there was an express choice of law which was not withdrawn. And nevertheless, I had this authority. So what did I do? I applied the law, and then at each stage, for example, whether there should be damages, and if so, how many, after I had come to the conclusion under the applicable law, I then asked the question myself and answered it in my award. Is that a result just and fair? And normally it is. But there are situations where the direct application of a specific law, any law, leads to a result result that is not fair.
Absolutely.
Yes,
Leidylin, please.
just a brief consideration in addition to what Axel used to comment. Even, and I will keep mainly on the investment arbitration field, even when it is referred in many arbitration rules, in, for example, like SID convention, is not that often applied on investment cases. Normally there is the tendency to consider that a decision under ex aequo et bono will be contrary to the law. That's sometimes the perception. But even in the cases where parties provide the tribunal with a mandate to decide on ex aequo et bonus, it's not an unlimited power for the tribunal. The decision cannot be arbitrary. There is even under that decision some limits that the tribunal should respect. The award, for example, should be reason, otherwise it could be a no. And there is a few conditions, and even when the tribunal is deciding ex aequo et bono, it doesn't mean that it cannot look at the positive law. So the tribunal has the power to do so.
May I add one more thing, please? Of course, even though the parties are in control of both in an arbitration, of both the proceedings and also the choice of law, or rather opting for ex aequo et bono, they cannot avoid public policy, or what's also called the ordre public. So, for example, you cannot dispense of the application of competition law, or as they say in the US, antitrust laws.
Well, we were mentioning, Leidylin, thank you very much, investment arbitration. You have pointed out in your introductory speech earlier this morning what investment arbitration is. And really for a commercial arbitrator such as myself, it's always very interesting to understand, is it actually the same thing? Is investment arbitration the same as commercial arbitration? It is, of course, a dispute resolution method. But does investment arbitration have particularities that make it entirely different and that should make it subject to different rules about conduct of the proceedings? Or is it basically the same system with an additional twist linked to the presence of a state party in this context? We maybe have a few words from you, Leidylin, about that, and then Miroslav perhaps wants to add the state perspective as well.
Yes, absolutely. One of the main differences between investment arbitration and commercial arbitration is the conduct that is being reviewed. For example, in commercial cases with state participation or state entity participation, what you request under a claim is whether the state, the government, has fulfilled its commitments under the contract, whether it fulfilled the contract, whether it made the payment that was requested. But in the case of investment arbitration, what the claimant demands is whether there has been a discrimination against an investor in comparison with an investor from a third party, whether that investor has been expropriated without any compensation. That follows the whole formula on compensation. So there is a difference in the conduct of the state, the measure that has been taken that allows for an investor to establish an investment case against that government by comparison of what is clean under commercial cases. Nevertheless, there has been situations where the same act has been used by claimants not only to pursue a commercial arbitration, a commercial case, but also for investment arbitration purposes. the procedural basis, they share common procedural basis, but there is different rules applied to each procedure. Whether you have a contract, for example, with an ICC case or LCIA case, or in the case of investment arbitration, whether you are presenting a claim under an international investment agreement, but also some local investment laws enable the investors to present investment agreements against that host state. In Latin America, for example, there was the case of El Salvador, whose national investment law allowed for investment arbitration, but also in state contracts, it can be provided a clause with ICSID as the forum for resolving the dispute.
Okay, ICSID is an institution of the World Bank, just
Yes.
for
International Center for
the
the Settlement
record,
of
yeah.
Investment Disputes.
Miroslav, maybe also from the state perspective, a few words about the differences.
Yes, thank you. In my contribution, I will point out the specific aspects of bilateral investment treaties with respect to application of ex bono et equo investment arbitrations. So, as you know, and as we heard it, the bilateral investment treaties, or as we call them, BITs, are the international agreements between two states. By a BIP, the state hosting the foreign investment provides the protection for the investors of the other contracting state, the home state of the investor. To put it simply, by a BIT, the investment, foreign investments are protected against unlawful treatment by a host state. So if the host state breaches the BIT, the investors, as a private entity, has the direct recourse to international arbitration, what is quite unique in public international law. In comparison to BIT, the investment contract is concluded between the state and particular particular investor. By this contract, the state provides preferential treatment for the investment of that investor, for example, tax holidays or promise of certain legislation, or, for example, more favorable regulation of the investment. Now, let's make distinctions between investment contractual arbitration and investment treaty arbitration. In investment contractual arbitration, the state and particular investor may agree that their dispute will be resolved by an independent tribunal. So this agreement constitutes the jurisdiction of this tribunal. From the perspective of substantive applicable law, they may also agree that the tribunal will not be bound by legal rules, but that it will rule based on ex equo et bono, which means outside the law. On the other hand, the investment treaty arbitration is the dispute resolution sui generis. Contrary to investment contractual arbitration, the investment treaty arbitration is based on the international treaty concluded between two sovereign states. This treaty gives the right to the third entity, the investor, that it can bring the claim to arbitration against the state hosting its investment. One could say that the host state gives a unilateral, open and blanket consent to arbitration to an unknown investor. This investor can anytime in the future legal remedy by suing the host state in international arbitration. The elementary source of law in investment treaty arbitration is the bilateral investment treaty itself. It contains the substantive obligation of the whole state how to treat foreign investments. The secondary source of law is customary international law, including the public order of the place of arbitration. In some BITs, there is also national law which can be part of the applicable law. While in others BITs, the national law of the whole state may be considered by the tribunal only as a matter of fact. However, there is no provision in a BIT that the tribunal may decide on ex equo et bono. The substantive provisions in especially old BITs were drafted in very uncertain and vague terms, so the tribunals are in some situation forced to fill the gaps to the extent to which the applicable law is not sufficient to cover the factual situation of the case. This implies to me the question, might the tribunal, BIT tribunal, be allowed to rule ex equo et bono? In my view, formally, this is possible since the BITs refer to separate arbitration rules, ICSID and UNCITRAL, which allow the disputing parties to agree or to opt for ex equo et bono. On the other hand, the practical usage of this institution is to me at least questionable, mainly because of three reasons. Firstly, the BIT as a primary source of law does not recognize ex equo et bono ruling. Secondly, if the whole state and investor as disputing parties agree on application of ex equo et bono, this would be without an explicit consent of the other contracting party to the BIT, the home state. And finally, the application of ex equo et bono would, in my view, go against the very nature of BITs, which provide legal investment protection for investments, while the ex equo et bono is not based on legal rules. So, to my best knowledge, I'm not aware of any BIT case which would be resolved by ex equo et bono. Thank you.
Thank you very much. Perhaps now we... And we've spoken with Elsa at the beginning of the timetable, procedural orders. Perhaps a few comments about the hearing as well. Maybe, Kishore, if you want to share a few thoughts about the organization of a hearing, the optimal way to conduct it from your experience.
Okay, this definitely works. Thank you, Edgar. Feel free to stop me in case I take too much time in selling my arbitral institution. My name is Kishore and I am from the KL Arbitration Center. Now, as far as an institution's role in affecting the conduct or proceedings of arbitration, I would think that's only one part of the role the arbitration institution plays in facilitating the arbitral process. Now, my presentation is also going to be a case for choosing institutional arbitration over ad hoc arbitration. And I think the role we play as facilitators and enablers when it comes to the proceedings of arbitration, that is the micro level kind of contribution we give. to the process. But at a macro level, we also have to balance international and domestic needs of parties as well as regional needs. And a third prong of what an arbitration institution does to assist the conduct of arbitration is we keep up to date with market trends through innovation and capacity building. So I'll talk about the micro measures we have in place to assist the arbitral process. Okay, this comes down to balancing time, cost, and quality. So how do we save time? First of all, we have fixed timelines. If you have an ad hoc arbitration, there is no specific rule to determine what happens after a certain amount of days. And if parties can't agree, things take a longer time. So while we do provide for party autonomy, we allow for parties to choose the appointment procedure, we allow them to choose the arbitrator, we allow them to choose the types of rules, the seat, even the venue of arbitration. But institutional rules will provide for a default position in case parties cannot agree. And we also have a model arbitration agreement if parties don't know how to refer to arbitration. And even if they don't have a model agreement, we have a model submission agreement. All this to help parties get into the arbitration process. And then we also get involved in the appointment process. Institutional rules will normally provide for a default appointing authority. So if parties cannot agree, they know who to go to appoint an arbitrator for them within time. And we go one step further to maintain the credibility and the integrity of our decisions. We ensure that proper conflict checks are sent out. We make arbitrators sign declarations that they are impartial, that they know the role they are taking on, and we make them abide by a code of conduct. Even where parties agree to selecting an arbitrator, the institution will verify and confirm that appointment, so that arbitrators, whether they are ad hoc appointments or not, they know that they are being held to a certain standard. We also appoint emergency arbitrators where parties need quick interim relief. Institutional rules will provide for appointment of an emergency arbitrator too, and we do it in 2 days. Costs. How do we manage costs for parties? We have a capped set of fees so that there's certainty and there's no hidden costs that parties will suddenly be faced with like in court. The capping of fees is done through a schedule that is based on the amount of claim and counterclaim. So the fees will be a percentage of the claim and counterclaim. Now we face issues where usually the respondents, if they have deep pockets, they will try and use guerrilla tactics against the claimant and bring up exorbitant counterclaims, raising the cost of arbitration. But with institutional rules, today a lot of institutions provide rules where the director or the appointing authority has the power to apportion costs. So that balances things between the parties. Finally, how do we control quality of the arbitral process? The rules will usually provide for comprehensive coverage of all the aspects of the arbitration, from commencement, which is a big issue because parties usually have this debate about when the arbitration was commenced, and that affects limitation periods. But the rules will tell you exactly when commencement date is. The rules will provide for appointment, the conduct of proceedings from start to finish, and even rules on the format, effect, and interpretation of awards. So there's a set quality. And over and above that, a lot of institutions will provide for technical review of awards as well. Before an arbitrator releases the awards, you send it in for verification with the institute. Now, some institutes take a very hands-on approach and they insist on certain amendments being made to the awards. But at KLRCA, we only provide suggestions. And of course, we know how lawyers are with numbers. So when it comes to costs and interest, KLRCA, in doing their technical review, would give assistance in that regard. My last point about the micro measures that an institution plays is the administrative role of the institute. People like me. So an institute will be a repository for your deposits. So there's safety and security. We will handle the invoicing and reminding the parties to pay so that we take away that role from the arbitrator. And we serve as a point of reference for both the tribunal as well as the parties. So if either one has any questions about the proceedings or how to move forward, they can always get in touch with the institution. We are the gatekeepers of commencement, so if your application to refer your matter to arbitration is incomplete, we will tell you that it's incomplete and we won't let you commence until it is. Finally, the legal team at an institute will ensure compliance with the New York Convention and other enforcement requirements. So that's the micro measures we put in place to manage the conduct of proceedings.
Thank you very much, Kishore. I must say, as an arbitrator, I do not appreciate very much institutions who tell me what I should or should not put in an award. I do appreciate comments, suggestions maybe about typos and perhaps some elegant way to prevent errors, but it's true that I'm happy to hear that at your institutions you're committed to preserving the independence of the arbitrator, which is, in my view, extremely important. So now to our last panelist, but not least, of course. Roopam, maybe you can tell us about different kinds of arbitration. We've heard about commercial arbitration. We've heard about investment treaty arbitration. Maybe you can tell us what is and what is not. And maybe I'm very curious to hear what is innovative arbitration in particular. If you'd like to speak here, it's as you like. So please, maybe you should come here. This one is working. And in the meantime, I sit with you.
Thank you, Edgar. So we all have the brochures from the Court of Innovative Arbitration, and I'll just briefly address everybody on what is Court of Innovative Arbitration. In India, we've been seeing the entire arbitral process has been very over-sophisticated, over-lawyered. It has also been suffocated by a plethora of detailed rules, laws, and guidelines. And we now need a system which takes us back to the roots of arbitration, which was simple, relatively informal, a procedure which was not lengthy and not very costly. So the Court of Innovative Arbitration, it aims to more closely resemble the early days of arbitration, which was simple and obviously informal. It is basically where two merchants in dispute over the price or quality of goods, they come forward to and they turn to a third person whom they know and they trust. Similarly, the Code of Innovative Arbitration also tries to achieve this goal mainly by relying on the two pillars. Firstly, the procedure is kept as simple as possible, not only to minimize the time and the cost factors, but also to give the arbitrators more leeway in adopting the most suitable approach for the case before him. And second, like everybody spoke, ex equo et bono. Court of Innovative Arbitration strongly encourages ex equo et bono. It means, as Axel told us, to decide in justice and fairness. Although this is not mandatory, but the Court of Innovative Arbitration has, over the period of time, relying more on ex equo et bono when it comes to making fair decisions. If the party use unmodified model arbitration clause, they expressly empower the arbitrator to decide ex equo et bono under COA. Likewise, if there is no express agreement on any applicable law or on ex equo et bono, the COA arbitration rules allows arbitrators to decide unless he finds it more appropriate to apply the law most closely connected to the dispute. And in my opinion, I think we, in the domestic arbitration in India, we need such kind of ex equo et bono decisions more, so that we not only have fast decisions, but also fair. We have less appeals, we have more trust in arbitrations that it is not taking more time. I would like to put behind the idea behind this ex equo et bono, for which the Court of Innovative Arbitration was actually launched for commercial arbitration. They have to apply legal systems in which they have not been trained, which often leads to difficult situations where both parties submit expert opinion on foreign law but reach different results, or neither party makes any helpful submissions in applicable law. This consumes more time and cost. The trend in arbitration in India is critical of application of this ex equo et bono, as I already spoke about. And the reasons behind why I see the critical approach is the parties are not willing to pay in order to simplify arbitration, maybe, and they think that the outcome is unpredictable. Well, if that was so, the parties should indeed engage in ex equo et bono arbitrations only in special cases and when both of them know the arbitrators well. I think what India, or the domestic arbitration in India at the moment, this is a system where arbitral tribunals can resolve disputes on the ground of what is fair and reasonable, and the arbitral tribunals in India should more base their decisions on fair and reasonable than any particular law with the help of equity clauses, provided that the parties agree so. Whether there is a difference between an equity clause, a clause requiring arbitral tribunal to decide ex equo et bono, and a clause that permits the tribunal to act as amiable compositors, as Axel already enlightened us with. The only difference which comes is, I think, that the equity clause would free the arbitral tribunal from the constraints of national law, while a clause requiring the tribunal to act ex equo et bono only permits the tribunal to lessen the effects of harsh law. The practice of ex equo et bono does not result in lack of predictability, what we often see coming from the commentators in India. In the vast majority cases, the arbitrators may do only a simple thing. They just apply the parties' contract. Only in rare circumstances do arbitrators feel compelled and in fact empowered to disregard a contractual provision on the basis of general consideration of justice and fairness. Obviously, I think there is a certain degree of unpredictability about whether or not a clause will be found sufficiently unjust to be disregarded by a certain arbitrator, and I think this is likewise in most jurisdictions. But the question to be considered is whether it is so different from international arbitration, where there is a widespread sensation that arbitrators applying a foreign law tend to take a decision that they deem fair and sensible, as long as foreign law appears to allow for it. This is a question, I think, which is majorly in discussion, also in many jurisdictions of international commercial arbitration. I think in particular in many cases in which applicable law has been agreed upon only after most of the contract has already been drafted can lead to unpleasant surprises when the governing law contains unknown provisions altering what parties agreed on. Under COIA, we look after this. These unpleasant surprises are taken care of, making your arbitration simple. And I think in my opinion, there is not much of predictability gap between traditional international arbitration and a traditional arbitration which is there under COIA. I think the ex equo et bono arbitration and international traditional arbitration will somewhere have a similarity if the arbitral tribunals have ex equo et bono arbitrations as a primary form, at least in contractual disputes. I would just like to conclude by saying that it will be very exciting to see whether arbitration users will be willing to test a system that attempts to turn back to the time in some respect. Thank you.
Thank you very much. Maybe before opening the floor for questions, we may want to address a few other practical points on which every member of the panel is happy to join the discussion if they have a comment to make about that. But we haven't heard much from our guest from Singapore, and maybe I want to start with her again with a few very practical points, starting with one point that Roopam just made. Very often in international contexts, you have expert witnesses who opine about the law applicable to the dispute. And of course, every party has their own expert, and very obviously, even though they are opining on the same law, they disagree with each other. And have you found effective measures to balance two opposing statements about the contents of the law as an arbitrator and administrator of proceedings?
That's a really difficult question. I think just backtracking to the party's choice on whether or not to enlist experts is an important one, because it's a very, very expensive sort of item to add to an investor-state arbitration and even to a commercial one. And you will have to expect that the tribunal will be looking to those expert reports quite closely to ground some of its more sort of technical conclusions on the law. Where expert reports are conflicting on certain points, I mean, the tribunal has to sort of weigh the evidence. And I think where they conflict substantially, that's where you definitely want to have cross-examination and have a full hearing, as opposed to deciding the case on papers only. But yeah, that's I think will continue to be a very important and difficult issue for arbitrators and also for counsel. Oftentimes, from a counsel perspective, you will have supplementary and even sort of third expert reports going back and forth. So do keep that in mind. There's always the chance for rebuttal, and you just have to apply to the tribunal and ask for that, for leave to submit another report.
One way I have also found effective is when I have conflicting reports from experts, be it about the law or a technical issue. I ask the experts of each party to have a conference with each other and to give me a brief summary on the points on which they do agree, in order to make appear what points they do not agree on, and we then concentrate on these issues. And very often I find it a good idea to hear them. But Axel, I think you wanted to add something about that.
Yeah, thank you. Just practical experience as an arbitrator. I so far never had felt it was necessary for me to get an expert opinion on a law that I was not technically qualified in, because what I do is I make the parties opine themselves, brief the matter, and usually you get to a convincing result that way already.
One procedural issue that very often arises is that the parties, of course, want to take advantage of procedural rules that are perhaps less strict than in state court proceedings to present evidence until the very last minute. And we're speaking at the very beginning of the procedural timetable. Do you find it is appropriate to restrict the parties in the timeline during which they can present new evidence? Is it necessary to present a cutoff date for that, in your experience? And this question is not addressed to anyone in particular. Anyone who wants to answer that? The cutoff date for the...
Well, if I may
yes,
start. I think it goes to the essence of arbitration proceedings versus most, at least, court proceedings, namely speed. You don't want to hasten anything, of course not. You want to be as thorough as you have to be and can be. But you have to make sure that things go fast. And lawyers in particular, party counsel, have the tendency of dragging things out for various different reasons, and you have to, as the arbitrator, really put your foot down and assert the authority necessary to make sure that things go fast, and cutoff dates belong there, and unless there's some really overwhelming issue or reason, one should stick to those dates.
And
I do agree.
just a brief comment. I agree. I totally agree with Axel. But there is some exceptions, of course, and it happened to us in a recent investment case where formally we have covered the document procurement stage, but in a later submission, then we discover some new elements that were not disclosed previously, and then we made the proper requestment to the tribunal, because there was certainly new evidence that we weren't able to see before. So there is, I agree with Axel, but of course there is some exceptions, and there are these kind of things that we see on a practical basis.
Mm-hmm. And maybe now a question about the presentation of the facts. Very often parties want to submit a lot of facts to the tribunal. Not all of them are relevant. In arbitration, of course, as the arbitrators act at the discretion and the basis of the consent of the parties, it's sometimes difficult to tell a party very strictly, no, I'm refusing this to be brought into the case. How do you think an effective and efficient conduct of the procedure should limit the parties in presenting irrelevant facts, maybe just to drag on the proceedings? Do you think the tribunal, the arbitral tribunal, should be relatively impose directions on the parties to that effect, or should it accept to hear whatever they want to say at the risk of dragging the procedure over a longer period of time?
May I just start by...
Sure, Roopam.
I'll just start by talking about the scenario in India at the moment. The arbitration proceedings have become more like court proceedings, where the tribunal is dealing with many prolonged dates and too many written submissions. Those are consisting of irrelevant facts, and the need of the hour today in India has become that we need to limit our hearings, our written submissions, which includes quoting the irrelevant facts. And we need a system where the tribunal either does not conduct oral hearings that much, and we only base our hearings on the documents, like we've seen in many other jurisdictions, or else the tribunal should, at the time of setting up the procedural timetable of the entire hearing, shall actually sit with the party and direct them that the facts should be limited. The written pleadings should be limited. The rounds of the written pleadings should be limited so that we can have a fast-track arbitration.
Does it make sense to, from the outset, limit the number of written submissions to one? Because very often I found the second round of exchanges of brief relatively inconclusive and useless. Not always, but sometimes.
I think in commercial arbitrations, perhaps one round will be enough. In my experience with investor state, you almost always need memorial, counter-memorial, and then reply and rejoinder. Back to the recitation of the facts, it's, as a counterpoint to what you said, it's also very important for the tribunal to ensure that each party has equal opportunity and ample opportunity to present their case. And so in that initial pleading, the memorial and counter-memorial, the parties are and should be free to express whatever facts they deem relevant. But one sort of behind-the-scenes mechanism to curtail that is to set a page limit on the entire sort of pleading. Similar to what you said about conflicting reports, once the parties have expressed the facts and their legal arguments in their written pleadings, in preparation for the hearing, one good tactic for an arbitrator to do is to ask the parties to submit, confer amongst each other, and submit an agreed sort of summary of facts, again, subject to a page limit. And if even within that, if there are facts to which they disagree, to highlight those. And then the same thing would apply to an agreed list of issues, because this can then really save on costs and time. And of course, the tribunal only gets its jurisdiction from the consent of the parties from what they plead. So an agreed list of issues will help guide their award as well.
And now, maybe before opening the floor to question, because I think we still have a little less than 10 minutes, if I'm not mistaken, about that. I would like to know about witnesses to the fact. Personally, as an arbitrator, I do not like to hear witnesses for reasons I can develop later if this is desired. But I don't like witnesses. In your experience, is it a good idea to request the parties to file witness statements with their submissions? Or is it best to not have any written statement before and just hear the witnesses at the hearing? And I can understand that there are several traditions in that respect, some even combining the two. We request witness statements and then we hear the witnesses in order to be able to cross-examine them. So what's, in your view, the most effective approach in that context?
Since I have the mic, I'll start and then I'll pass it on.
And then Miroslav, I think. Yeah.
Sorry.
No. Go ahead.
Okay, well, this is something that should be set out in your procedural order number 1, just to cover yourselves. In investor state arbitration, you will almost always have written witness statements followed by, it's the party's choice which witness statements it wants to present, and then the counterparty, the opposing party then selects which ones it wants to cross-examine. So, but it's interesting to see in commercial arbitration, oftentimes in smaller cases, it just makes more commercial sense, it's cheaper, and more time efficient to simply hear them at the hearing.
Thank you. Just a very short remark. In our practice with investment treaty arbitration, we always file witness statements together in submissions because we just want to prevent surprise at the hearing. So this is the reason.
It has been our experience too. The witness statements all together with the submissions, but then at the hearing stage they also present before the tribunal. And it's incredible the kind of situations that you face with witnesses. Very, very impressive.
Very often I find witnesses to have a selective memory.
Yes, absolutely.
Anyway, we've talked about the details of the conduct of the proceedings. Are there ways, you were speaking, Kishore, about micro measures. Are there macro measures that are designed or maybe used to improve efficiency of the procedure? Kishore and perhaps then Axel. Sorry, or first Axel, since he has the mic.
Yeah, okay. Thank you. I use this opportunity, if I may, to put the whole thing a little bit more in perspective, namely with respect to the involvement of the courts themselves, also in an arbitration. I think that is important to note, and especially perhaps in India at this stage where the government is still looking to improve the way cases could be dealt with by arbitration. And I think it's important to nevertheless remember that whether there is an arbitration or when there is an arbitration, the ultimate decision technically lies with the courts, because an award you can appeal or bring an action for annulment, as it is technically called, against in the state courts. And there the question is which state courts, and Switzerland is a very good example of how to deal with that efficiently. In Switzerland, an award can be must be taken directly before the Supreme Court. End of story. In most other countries, it's the Court of Appeals level, and whose decision you can then take further to the appeals court. So sometimes people are suspicious of arbitration in whatever context because there are those private law arbitrators that run amok or do as they please. No, the final word is always with the state courts.
While you pass the microphone to Kishore, a word about Switzerland. Indeed, Switzerland has an approach where state courts have a very limited role in arbitral proceedings, maybe to support the formation of the tribunal if the parties cannot agree on the arbitrators, maybe on a limited number of procedural support measures, but then the appeal, yes, first only to the Supreme Court, and second, only on very limited appeal grounds. Basically, you can say that you haven't been heard properly, but on the merits, there is practically no way to appeal an arbitral award when the seat of the arbitration is in Switzerland.
Thanks, Edgar. Yeah, there are some measures that can be taken by an institution that's very often outside the realm of practitioners and parties. And these are measures that institutions put in place to create an environment that's conducive for arbitration and dispute resolution. Some of the things that we do is we provide a panel of arbitrators with over 1,000 arbitrators for you to choose from, spanning 74 countries, different languages, and over 30 practice areas of specialty. And this is one of the things that an institution can provide to assist the entire arbitral process. Apart from that, legal services. KLRCA's legal team, the team that ensures enforcement and compliance with the New York Convention, hail from different countries, both civil law and common law jurisdictions. And on top of that, an institution like ours will provide you with world-class facilities, so you don't have to worry about transcribers. We have facilities for video conferences for parties that are based overseas. Another huge aspect that comes with an institution is neutrality. So there's a lot of fear that parties, they don't want to come to an institution or a center that is aligned to a particular country or a particular ministry in a lot of cases. And in this sense, KLRCA is very lucky because we are not aligned to a country. Although we are based in Kuala Lumpur, we are not really aligned to Malaysia or the Malaysian government. We are a creature of this organization called the Asian African Legal Consultative Organization. If you haven't heard about that, it is based here in Delhi, and it was set up post-World War II to assist developing countries in Asia and Africa to resolve disputes, as well as to advise them on drafting international laws, drafting constitutions, drafting international agreements. So what the Asian African Legal Consultative Organization, we know it ELCO, what ELCO did was they set up 5 regional centers around Asia and Africa, including Cairo, Lagos, Tehran, Nairobi, and Kuala Lumpur. And because of this, KLRCA is a neutral ground, and we are recognized as an international organization by the Malaysian government. And this helps the entire arbitral process as well, having that cloud of neutrality. And then there are measures that we take in keeping up with market trends. We keep in touch with a lot of industry groups who we call stakeholders in the arbitral process. We have a particular relationship with the construction and maritime industries in Malaysia, which brought about the introduction of KLRCA's fast-track rules for disputes that require decisions fast. We also have rules specifically catered to Islamic finance disputes. And we are now working with the securities industries, the sports industry, as well as the intellectual property and domain name markets. We collaborate with we collaborate with the judiciary. We provide training, we give them awareness, we expose them to the intricacies of enforcement, and we also engage with policymakers. And this is very important because if you want to give bite to any arbitration rules, there has to be legislation to back it up. And having a good relationship with policymakers makes a huge difference, especially when it comes to referral of arbitration, the court's role in referring matters to arbitration, enforcement of awards, competence and competence. These things can be codified in your law, and it can make the arbitration process that much more viable.
Thank you very much. Perhaps in the last very few minutes of our session, maybe if there are questions from the audience, I think the members of the panel will be happy to take them. And if there are none, we'll take questions from the panel.
I think it might be useful for one of our investment experts, state investment cases, to say what an investment actually is, or more importantly, what would not qualify as an investment.
It's a very open concept. In part, it depends on on the definition of the agreements. For example, you have many VITs with a very open definition. The concept of investment, it includes every kind of assets, and then it establishes an open list of what qualifies as investment. For example, in ICSID convention, there is no definition on investment, and it was done on purpose. But with the different decisions coming out of the tribunals, some characteristics have been identified for investment, and are those characteristics what we have tried to include in the last generation agreements to provide what we consider it is an investment and what we do not consider to be an investment. For example, the economic impact of the investment within the host country, the time that it has been placed in the host country, and whether there has been any risk involved. So these kind of elements are being considered to qualify as an investment. And for example, in our latest VIT model, we specifically included what we do not consider to be investment, because we have had cases where I can tell there was no significant investment involved, but nevertheless we received claims for $680 million, $550 million. In one of the cases, literally the investment was $2. It involved some share assets, and it was $2, but the claim was for $550 million. So it's a very important issue to deal with, and it's a concern that states have been taking into consideration in order for future agreements and for their BIT models.
I think this shows that the question of damage in international arbitration, in particular in investment treaty arbitration, is very important, because it can significantly, it can be significantly more than the amount of the original investment. Maybe Miroslav.
As you said, the definition of investment is probably the most important provision in a BIT, especially in old BITs. We had to face often very speculative claims brought by speculative investors, where they tried to enlarge the scope of the application of BIT. So in our new BITs, we try to draft this provision as precise as possible to avoid such arbitrations. We even go that far that we provide for a negative definition of investment. It means what the investment is not. So this is our approach in our model BIT, to have as precise provisions as possible, to have the clear ground for arbitration cases.
Perfect. Thank you very much to all the panelists for their very valuable contribution to this very vivid discussion. And I think that for the promotion of India as a place of arbitration, I think it is important to have investment arbitration rules in place. I think it is important to have a limited involvement of the state in the conduct of the proceedings, and I think it is extremely important to have efficient arbitral institutions that work on the basis of clear and lean rules. Many thanks, and a good continuation of this seminar. Thank you very much.
To summarize dispute resolution in general, I have a quote by Joseph Grinbaum, that is, an ounce of mediation is worth a pound of arbitration and a ton of litigation. And the development of international arbitration is considered from a standpoint of its ultimate benefit to the human race, is the most vital movement we have of today, of the modern times. I would like to thank this esteemed panel for the great discussion, and I request our moderator to please present the mementos to the speakers. I request Rakhi Biswas ma'am, General Manager of Mindtree, to please present the memento to sir. Thank you once again. I think we can break for lunch.